call the zoning board of adjustment special meeting being held today at 6:30 at City Hall, in the City Hall Council chambers. We will have a call to order, announce a quorum is present. This time we'll have a citizens forum. So the ZBA invites citizens to speak on any topic. However, unless items specifically on this agenda, the ZBA is required on the text committee tag to limit its response to responding to specific factual information reciting the city's existing policy or directly the person making required to visit the city staff about the issue. No board deliberation is permitted. Each person will have 3 minutes to speak. This time, is there anybody to speak?
No, sir.
Okay. So we'll move into the regular agenda. Item number 1, we'll have received legal advice and guidance from city attorney regarding the substandard structure process.
Do we want to go into executive session for this, or do you want me to do this in open session?
Open session is fine.
Okay, so basically, the process for a substandard building hearing is pretty well laid out in your ordinances. It talks about, the forms of notice that were required, the entities that are required to receive notice. It lays out, what sort of things that you can consider when making your decisions and your findings. It outlines what types of findings that you can make. There are basically 3. One is a finding of no violation, at which point the city's investigation into the property stops. Now, that does not preclude that does not preclude the city from continuing on to another case, another enforcement action. But everything that the city has presented up to that point, the board will have determined that there was no violation and there was no substandard property. The second finding that you can make is that the property needs to be repaired. And with respect to that, there are certain timeframes in which the board can order the owner or a lien holder to repair the property. The last finding that the board can make is to demolish the property. I believe that looking at the agenda, that is what the city is requesting, is the ability to demolish the property. The ordinance doesn't really dictate the specifics on the hearing. That's really up to the board to make its determination on how the board wants to conduct the hearing. There are 2 basic principles that just need to be adhered to in the hearing. One is just fair due process for the owner or lien holder, that they have a fair opportunity to make their case. And looking over your agenda of how you've laid it out, with allowing the city to make its presentation, the owner to make its presentation, and then allowing for public comment in favor or against, and then allowing the owner a rebuttal, I think meets that requirement. So it meets the due process issues. The other thing that I would suggest the board and make a decision on at the beginning is whether or not the parties can question each other, or if they're limited to making their presentations and the board is the only party that can ask questions of the presenters themselves. That is entirely up to the board on how they wish to do that. And there's no issue with either decision. It's entirely up to the board. Afterwards, after you make your finding, there will be a draft order that'll be prepared for you. And there's some certain specifics that need to be in that. And I'll work on that to make sure it meets all the legal requirements. And it'll specifically outline what the board had found and what its requirements are with respect to the property owner, either repairing, demolishing, or that no violation was found. That's pretty much the outline of the procedure. It's very similar to variance requests and things like that, where you are the fact finders. It's your decision to make, both sides will present facts to you, and then you will make the decision as to whether or not to, whatever order that you want to make. But it doesn't have to be under rules of evidence or anything of a court of law. This is a quasi governmental or quasi judicial determination. Does anybody have any specific questions or some other information that you would like me to provide?
The only question I would have, based off the information that you sent to us earlier, in regards to the availability of legal proceedings. So will we be covered through the process tonight to not recommend that direction, or do we have to recommend that direction and go there either way?
I'm sorry, I don't think I understand what you're asking. Are you concerned about which way the board makes the determination on how it's going to conduct the hearing?
Not to conduct the hearing, it was, let's see. Yeah, this is the same thing. I noticed there was comments that you'd written to us about the legal challenge aspect.
Oh, yeah, I can explain that, but I would not like to do that in open session because I would I'd vitiate attorney-client privilege. I'm happy to do that in executive session, but I don't want to provide legal advice in an open setting and lose the confidentiality with you all.
Okay, then at this time, we'll convene that aspect and go into executive session at 6:35.
Okay, I'm going to pause the recording. Hold on 1 second.
Session. Okay, so we reconvene back into open session. We'll go to item 2 on the agenda, which is this time we will open the public hearing to consider abatement to cause repair, vacation, relocation, documents, removal, demolition, and securing the building in the R1 single family residential district being lots 1 and 2, block 1, Rumbox edition, block 177, page 365 of the deed. Records of Johnson County, Texas, located 200 Wayside Street, Joshua, Texas. This time we'll have a staff presentation.
I'll start out with the background information. February 18th, 2018, at 5:04 a.m., the Joshua Fire Department responded to a reported house fire at 200 Wayside Drive. The house suffered heavy fire damage at the top story of the house and some fire damage to the bottom floor. It was determined by the fire marshal that it was caused by a possible electrical short. April 9th, 2019, Code Enforcement Officer Charles Cobo started the process of substandard and dangerous building case by emailing a letter to the owner, Cynthia Jones. Mrs. Jones did respond to the letter stating she had an architect working on plans to rebuild the house. Ms. Jones and her contractor did meet with Charles Como and the permit tech regarding the rebuild. The contractor removed the majority of the second story. No other work was performed on the house. July 27th of 2020, a substandard and dangerous building process started over with Code Enforcement Officer Charles Como. Second letter was mailed on August 24th, 2020. Mr. Como did not receive any contact back from Mrs. Jones. July 27th, 2021, Fire Marshal Joy Kratky started a substandard and dangerous building case on the property located at 200 Wayside Drive, owned by Cynthia Jones. The first letter was sent certified mail to Mrs. Jones on July 27th of 2021 regarding the condition of the house and to contact Fire Marshal to set up a meeting. The letter was signed for on August 4th, 2021 by Mrs. Jones. City staff did not receive any contact by Ms. Jones by the due date of August 5th of 2021. August 26th of 2021, a citation letter was sent, certified, mailed to Mrs. Jones. Postage was signed by Mrs. Jones on September 9th, 2021. Ms. Jones did not contact city staff by the date on the letter of September the 15th of 2021. September 9th of 2021, Fire Marshal Kratky posted substandard building signs at 200 Wayside Drive at the front door of the house and on the north side of the house facing 14th Street. Pictures were taken after the signs were posted. A sign was mailed to Mrs. Jones, deeming the house a substandard and dangerous house by the city of Joshua's ordinance 3.03, section 3.03.005. Mrs. Jones did sign for the letter on October 7th of 2021. Ms. Jones did not contact city staff by October 15th of 2021 to discuss the property. September of 2021, Fire Marshal Kratky attempted to contact Ms. Jones by email and phone, but did not receive any response from Ms. Jones. The city of Joshua building official and fire marshal feel that the house is substandard due to the following in the city of Joshua's ordinance 03, section 3.03005. Whenever a building is dilapidated, substandard, or unfit for human habitation and a hazard to the public health, safety, and welfare, in the opinion of the building official, whenever any building is in such a condition as to make a public nuisance known to the common law or in equity jurisprudence, whenever any building is abandoned so as to constitute such building or portion thereof an attractive nuisance or public or hazard to the public, any building constructed and still existing in violation of any provision of the building code, fire code, life safety code, plumbing code, mechanical code, electrical code, housing code, or international property maintenance code of the city, to the extent that the life, health, or safety of the public or any occupant is endangered. Whenever any portion thereof has been damaged by fire or earthquake, wind, or flood, or by any other cause to such an extent that the structural strength or stability thereof is materially less than it was before such catastrophe and is less than the minimum requirements of the building code for the new buildings of similar structure, purpose, or location. Whenever the building or any portion thereof, because of dilapidation, deterioration, or decay, faulty construction, the removal, movement, or instability of any portion of the ground necessary for the purpose of supporting such building, the deterioration, decay, or inadequacy of its foundation or any other cause is likely to partially or completely collapse. Whenever, for any reason, the building or any portion thereof is manifestly unsafe for the purpose of which it is being used. Whenever the building, exclusive of the foundation, shows 33% or more damage or deterioration of its supporting members, or 50 or more percent damage or deterioration of its non-supporting members, enclosing or outside wall or coverings. Whenever the building has been so damaged by fire, wind, earthquake, flood, or other causes, or has become so dilapidated or deteriorated as to become an attractive nuisance to children or a harbor for vagrants, criminals, or immoral persons. Chapters 3 through 7 of the 2015 edition of the International Property Maintenance Code, published by the International Code Council, attached to Ordinance 653-2016 and incorporated herein for all the municipal purposes and amended herein are hereby adopted by the City Council to the extent that they do not conflict with other provisions of this article. For purposes of this article, any building, regardless of its state of construction, which exists in violation of chapters 3 through 7 of the International Property Maintenance Code to an extent that endangers the life, limb, health, property, safety, or welfare of the public or the occupants thereof shall be deemed and hereby is declared to be a substandard building and a nuisance. That's it.
Okay, so at this time, we have an owner's presentation. We reached out, I guess, no word
Yes, sir.
from owners.
Well, actually, she did contact Fire Marshal Cracky, I believe last week. And
her jury trial for the lawsuit on that house has been moved to September 19th this year.
Okay. But again, there's no, that wouldn't stop anything on our part.
No.
At that point, she's had ample time to visit.
It's since 2018.
Right, right.
And she's already received insurance money for
Yeah.
that house. Now she's sitting on it.
Are there any liens on the property?
no,
Who should go to trial? What's the trial for?
She's suing Encore, because Encore's line what started everything.
Again, so at this point, there's no owner present, nobody here to speak in favor. Nobody listed to speak against, and there'll be no rebuttal. So at this time, we'll close the public hearing at 6:47. And move into item 3, discuss, consider possible action on the abatement of costs, repair, vacation, relocation, occupants, removal, demolition, or spring building in the R1 single-family residential district as listed. So at this point, any questions from the board? Questions, comments, concerns?
I recommend that we get the property demolished for the hazards that it presents, not only to the public, but to the property itself. There's no fence around it. Any child could go up there and get in trouble and get hurt. It's a nuisance in the neighborhood. All the neighbors have been complaining for the last 5 years. She hasn't made any effort to, and she's already received the insurance money. It should, something need to be started or be in progress. And the fact that she hasn't even showed up to rebut anything. I make a recommendation that we have the property demolished through the proper court systems.
Okay, so just to confirm, so we would make a recommendation that, and so I would accept Lynn's recommendation to demolish the property.
With the proper court proceedings being mailed out and taken care of.
Now with the
Court order.
Court order.
does it be a court order, or would it just be via the board and then?
So, board members, for tonight, it would just be your order. If they did not, if Ms. Jones did not comply with your order, then I would work with the city to initiate the proper proceedings.
Okay, so this time it would be straight in order from the board to give the property owner 30 days to demolish the property. That'd be,
Yes.
I would think a week, but I'm good with 30 days. Okay, so we got a motion by Glenn, amended for 30 days for demolition. We've got a second. So at this point, all those in favor? Motion carries 4-0. At this time, we'll adjourn the meeting at 6:49.
Thank you very much.
Thank you, board members.